Hi everyone, it's Nick Marzano. You hear that? It's so quiet. No intro music today. That's because this is the first interview episode of the podcast, and I have got to say you're in for a treat. Two treats, even. First, you're going to hear from Dr. James Greiner, professor at Harvard Law School and faculty director of the Access to Justice Lab. His work is devoted to advancing an evidence-based approach in U.S. legal practice. We'll talk about why law is decades behind medicine, and we'll get into how that relates to the role of the district attorney. If you haven't listened to that primer and you aren't familiar with the role of the DA, you might want to pause this and go back to episode 2. The second treat is that you're going to hear much less from me in this episode. That is, apart from some background noise and note-taking. My only excuse is that this was recorded back in early 2017 when this podcast was a wee nascent little project, and when I was much more naive about proper audio recording tactics for an interview. I was using this little earpiece recorder that, on second thought, is probably better suited to espionage than podcasting. I've since adopted a new process for interviews, I'm using different software, and I commit to you, fellow nerds, future interviews will be better. At the same time, I don't think it's intrusive enough to get in the way of Dr. Greiner's thought-provoking comments. He and his team at the Access to Justice Lab are doing some pretty revolutionary stuff, and I wouldn't want to let a little keyboard clack here and there deprive you of that. So with that, let's get to it. So I guess to start out, could you tell me a little bit about yourself and what drew you to this work?
Sure. I was a practicing lawyer for 6 years after law school and the clerkship. And up until took no math classes in college, no stats classes in college, anything like that. Basically, I got interested from the practice. My practice, I was doing employment discrimination class actions. I was doing redistricting cases, and those all involved some heavy numbers. And so I took the plunge and went back and got a PhD in statistics. And the thing that spoke to me most during my stats and during my early part as an academic was finding out what works and what doesn't for people who can't afford to hire lawyers to represent them in the formal legal system, and then for courts and for court actors like district attorneys, like public defenders, because I think that there are real structural barriers inside the practice, United States practice of law, that resist evidence-based thinking, especially randomized control trials. Randomized field experiments, as you said, and I thought that was a pity because I think there's a lot that can be done with good knowledge to make the court system more effective for the people that need to use it or are forced to use it, forced to interact with it, and for those of us who care about the rule of law. And so that's why I do the work I do.
And so I heard, on the previous podcast that you were on, you spoke about the comparison with medicine, and what's the difference with law that is holding it back some 80 years?
Yeah, this is frustrating because many of the arguments that I hear in law when I propose randomized field experiments to try to figure out for what works are almost direct quotes from the reading that I did of the debates in medicine 80 years ago. I mean, they're almost word for word. And basically, what they come down to is something like the following. I am a professional, and because I am a professional, I have the ability to assimilate large amounts of information and make a professional judgment about what is best for the individual client or the individual case or in the medicine, the individual patient in front of me. And randomizing that person to find out what works is, number one, a disservice to that individual person because I already know through the exercise of my professional judgments what is best for that individual person. After all, I'm a professional. I must know. And number two, it is an affront to my identity as a professional because, again, what am I for if I'm not for the purpose of knowing what's best in each individual situation and tailoring each individual situation to the unique solution that it needs. And so not only is it true that, I'm a professional and I know best, it's also true that no two cases or no two patients are sufficiently alike to where you could get anything useful out of a randomized field experiment or out of any study, really, because every case is its own universe. And that's basically the set of responses that I typically get. And you put your finger on the source of frustration, which is those are all the same arguments that were made in medicine when the doctors said, well, look, we know what works with this new drug, or we know what works with, treating syphilis with gold, or different things like that. We know already. So why do we need to do this silly randomized experiment to tell us what works or what doesn't work? And the doctors eventually, the medical profession eventually fought a bloody intellectual civil war for the soul or the epistemology of the profession. And the conclusion they came to eventually enough of them came to, was that we don't know. And we can't tell. And even if we could tell in general, we can't tell enough to take care of things like dose, how much dosage you need, and we can't predict side effects well enough, and we need this form of knowledge, this rigorous empiricism that the randomized field experiment represents, in order to find out. Now, why did that take hold in medicine and not in law? I could only really offer just speculation on that, because the answer is I just don't know. I've speculated that one thing that might be going on is that lawyers need to feel more certain than physicians do, because a judge, for instance, needs to appear certain when the judge is sentencing someone, or else the world starts to think that maybe their emperor has no clothes, that maybe there really isn't good knowledge about incarceration that would justify the incarceration, or lack of incarceration that would justify the lack of incarceration. It might be socially damaging for the society to know that truth. It seems pretty thin to me, but maybe that's what's going on. Or it may just could be that we lawyers are convinced that we are just that much smarter than the physicians, and in fact everybody else in the world that is moving towards rigorous empiricism in some way. And that we are the last, bastion of arrogance, in which case, we need to get over it.
So what has been your approach to trying to bring some enlightenment to the field?
Yeah, what we've tried to do in both criminal and civil justice is to demonstrate through examples, through studies, several things. Number one, that the randomized field experiment can produce useful and non-obvious information, stuff that we didn't know before. And sometimes that will be things that are favorable to a particular legal services provider or a court, and sometimes it won't. But that we can produce good information. Number two, that we can do so in a way that is ethical and moral. And number three, that we can do so in a way that is not prohibitively expensive. It's never free, nothing is, but that we can do it. And so far, our primary way of trying to change hearts and minds is by producing examples of rigorous field experiments and rigorous empiricism. We're also attempting to gather startling examples from other fields, where we say, for instance, in medicine, we had hormone replacement therapy that everybody thought should be standard treatment for women of a certain age facing certain symptoms. But then there was, and based on the observational studies, it looked like that was right, and then we did some randomized studies, and it didn't turn out that way. Scared Straight from criminology became a popular TV program, and so everybody thinks it works. The randomized evidence that's out there suggests that it's a really good way, to increase recidivism rates, which, as far as I can tell, nobody likes. There are just multiple examples of these failures within particular fields where the professionals involved thought that everything was this again is a great idea. Let's do it, and let's don't wait to evaluate it because it's too important. One of the latest one is robot babies as a way to try to decrease pregnancy rates among teenage girls. And there's a recent randomized study out of Australia, at a minimum, calling into serious question whether it works. Whether they work and they're quite expensive. Actually, the robot babies cost a lot per robot. And maybe it turns out they're a good way to increase pregnancy rates. So we try to gather those examples. We're constructing a short course to try to show people, here's what you can do, and addressing everything from ethics to how you get one of these studies off the ground. So right now, the lab is trying to act as kind of a clearinghouse for this movement, and trying to engage other folks in the process. In the criminal justice sphere in particular, one of them is pretrial risk assessment scores. That have been the subject of intense debate, including among prosecutors, among district attorneys' offices. And so our view about pretrial risk assessment scores is, well, maybe they work, maybe they don't. Let's go test it and find out. And let's don't just say, do they work on one outcome, like do they reduce crime rates? Let's also measure a lot of outcomes. What are the racial effects of pretrial risk assessment scores versus having no pretrial risk assessment score? What are the release rates look like? What do the amount of time people spend incarcerated? What does that look like? What do the failure to appear rates look like? So we try to measure things on multiple different dimensions and provide policymakers with rigorous evidence that they can use to trade off different values against each other, because that's what policymakers are for.
When it comes to district attorneys in general and their performance, what sort of opportunities do you think, whether it's randomized control trials or randomized field experiments, what opportunities do those present for evaluating performance and sort of unlocking that black box a little bit?
Yeah, I think there are a lot of opportunities. None of them, it's not like it's really easy. You have to sit down and think hard to begin with about what you want out of district attorneys. What you want is high conviction rates, then maybe what you want district attorneys to do is to figure out how to select easily prosecutable cases up front and then win them. And so, and since district attorneys, and when they're running for office, often quote their conviction rate, saying, I've got a 97% conviction rate, I must be a good district attorney. There are two issues with that, because there may not be problems, two issues with that. One is, is all you did go pick the easy cases to win, so you didn't prosecute any of the hard ones, because that would have meant that you might have lost some of them, and that would have dropped your conviction rate. And number two, did we really need to convict all those people, or could we have diverted them to something other than the formal criminal justice system? So now you have to think hard about what you want out of a district attorney. Once you do that, there may be some things that you can evaluate with a randomized field experiment, or that a district attorney, herself should want to have evaluated, because that way she can tell whether the policies and practices that she has in place are effective. So as a district attorney, should I support the use of pretrial risk assessment scores or not support the use of them? To use that example, let's evaluate what happens when you have pretrial risk assessment scores versus when you don't, and let's take into account the factors that people care about. Things like amount of pretrial incarceration. Most people think that, all other things being equal, that there should be less pretrial incarceration. If we could keep crime rates the same or drop them, or if we could keep failure to appear rates the same or drop them, let's incarcerate fewer people. It costs less in terms of social costs, and it costs less in terms of economic costs. District attorneys could get behind randomized field experiments that would figure that out. Same thing with racial effects of pretrial risk assessment scores. Remembering that the alternative to a score is having a score present is to having the score non-present, which means an unguided human judgment. And there's increasing amount of evidence that unguided human judgments are subject to racial biases. So which one do you want? Pick your poison. We don't know. I'd rather pick the poison that is less damaging, right? And so I don't know which one that is. District attorneys could also implement things like, how should I assign particular cases? There's actually a public defender. It's a well-known study. A public defender basically randomized case assignment procedures within certain limits, and didn't do that to find out information. Did that because the public defender decided that it was a great recruiting tool for new recruits. The public defender said, I get better lawyers because I'm not going to stick, entry-level lawyers on super boring, cookie-cutter, high-volume cases. I'm not going to have them defending, traffic tickets right out of the gate. People come here because they know that pretty quickly in their practices they're going to get substantive work, really interesting, difficult cases, because I'm going to randomize the cases. Well, it turned out that some scientists could come along and learn something from that. Maybe that could be intentional, where we randomize some case selection and case assignment criteria and figure out what yields good results, however we define good results. Maybe prosecutors could do that as well. Maybe we could, have prosecutors figure out what makes sense in terms of, or what are some alternative ways to charge people, to make charging decisions, and then randomize those and figure out what would make sense in terms of reducing recidivism rates and increasing victim satisfaction with the process, victim satisfaction with the outcome, and minimizing expense on the part of the state of housing people if they're convicted, and minimizing the social costs to the accused and the accused families. I mean, all of these are important social values. And I think it would be fantastic if we had some idea of what charging practices would best, give us the best results with respect to all those different values. There are more that I didn't mention. So I think there's a lot of opportunities, both in terms of evaluating a prosecutor from the outside and having the prosecutor increase the efficiency and effectiveness of the office. And so, as a member of the public, one thing we could do is we could say to prosecutors, hey, are you using rigorous empiricism? Are you using randomized field experiments? If you are, good. That means I'm more likely to vote for you. If you're not, why not? Because if you're not, that means you for all we know, you're not using the most effective and efficient and fairest methods of doing business, and we care about that as citizens.
Would you say that something we should be asking from district attorneys is how they will define justice, and then how they will make that definition iterative, or that the promise of these sort of randomized either field experiments or controlled trials could be to iterate on that understanding of justice?
I do. I'm not sure how much the empiricism can bring to the debate of what the goals should be and what justice means. I see the role of empiricism more as, okay, if you have a set of goals, how can we reach them? And maybe how heavily should we weigh multiple goals, because we almost always have more than one. Because the empiricism is going to tell us, well, which one of these goals is actually feasible. But I actually have to caution the nerds that I talk to, including myself among them. We nerds need to be careful that we don't pretend like we can do more than we can with the empiricism, and we nerds often make that mistake. We often think, that something is an empirical question when it's actually an intensely value-laden question. And if it's value-laden question, we need to say that there are people that know more about those value debates than we do. In the case of district attorneys, since most district attorneys are elected, the people whose views matter most are the electorate, the people that elect the district attorneys. And so what we can do as empiricists is say, here's how you get from here to there, but you have to tell me where there is. You have to tell me where you want to go and what values matter to you. And I can suggest things to you, things for me to measure, given past work that I've done, or my research into this area, or my reading of what other people who weigh values have written or said. But ultimately, what you do with the information is not something that empiricism should have a strong voice in. Instead, empiricism should say, well, if you do this, this is likely to be your result. And would you rather live in that world or in another world? And so I'm all for iterative justice and strong discussions about justice and trying things out and seeing if it conforms with our sense of justice and being experimental in that sense. But the rigorous empiricism, we need to make sure that we stay in our place.
Well, I'm being mindful here of the valuable time you've already given in. Is there anything that I haven't asked you as it pertains to DAs or as it pertains to to how empiricism can be beneficial to criminal justice, or what we should be asking of our candidates or of ourselves that you would want to make sure was on this podcast?
I guess the critical thing for me is that DAs have a voice, a megaphone. People elect them, they interact with them, they depend on them, and DAs can be a force for rigorous empiricism and better scientific knowledge, even if the studies are not occurring in their own offices. Ultimately, whether a pretrial risk assessment score gets used, for instance, again, to stay with this example, may depend on it's a court decision. Does the court want it, and is it available? Are we going to hire court staff to do it? But it is crazy to think that a court, a typical court, would move in that direction and move to evaluate a pretrial risk assessment score or a sentencing policy without consulting a DA. I mean, it's just never going to happen. And so DAs can be an enormous force for rationality and for increased effectiveness simply by lending their voices to the idea that this is what we should be doing. We should be conducting rigorous experiments and using good information whenever it's available and getting more information when we don't have it. Even if, again, it's not their particular offices that are going to do the experiment. And so that's what and so as a member, of the voting public, that's what I'm hoping DAs will do, and that's what I would ask my DA to do.
I want to thank Dr. Greiner again for taking the time to talk with me about his work, especially months before this podcast had launched a single episode. I think that speaks to just how passionate he is about sounding the call for a greater focus on empiricism. Now, if you have thoughts on this show or ideas for future shows, please share them. Don't be stingy with the thoughts. Let those thoughts free. I have primer episodes planned out for months, but I'd rather prioritize what's important to you. You can follow me on Twitter at Local Nation Show, like the show on Facebook at Local Nation Podcast, and if you like what you've heard in the first few episodes and you want to hear more, please take a moment to rate and review the show on iTunes or Stitcher. In the meantime, thanks for listening and for being an above-average citizen.